Hello, Dr.A.Paramasivam. Hello, sir. Hello.
Hello.
Hello. Hello. Hello. ஒரு கூகுள் மீட் இன்னொரு கூகுள் மீட் சார் இப்போ லைட்டில் பண்ணோம் சார் ஆச்சு சார்
எனக்கு ஐடியா இல்லை. அதில் ஆடியோ டிவைஸ் உண்டோ? ஓகே. ஆடியோ
இல்லை அது கொஞ்சம் டிலே ஆகும்.
சார் கேன்சல் பண்ணுற வசதி போடுறேன். நைட்டு போடுறது பழசு பேசணும் தான் வருது. பழசு போட்டதான் பிறந்து இப்போ நம்ம பேசுறது தப்பு.
இப்போ யூடியூப்ல வருது ரைட்டில் வருது அப்படின்னா இப்போ வந்து எதுவுமே ஸ்ட்ரீம்லாம் ஸ்டாப் பண்ணக்கூடாது. ஸ்டாப் பண்ண பிரச்சனை ஆகிடுது சார். அது போயிடுது. அந்த எண்டு ஸ்ட்ரீம் கொடுக்கக்கூடாது, இங்கேயும் கொடுக்கக்கூடாது, அங்கே ஸ்டாப் ஸ்ட்ரீம் கொடுக்கக்கூடாது, அங்கேயும் கொடுக்கக்கூடாது. அதுக்கு அதே மாதிரி இங்கே எண்டு கொடுத்தாலும் இது போயிடுது. இது ஒன்றும் பண்ண முடியல. மறுபடியும் இன்னொன்று க்ரியேட் பண்ணுற மாதிரி இருக்குது. இன்னொன்று க்ரியேட் பண்ணால் அந்த லிங்க் மாறிடும், யூடியூப் லிங்க் மாறிடும். நான் இப்போ யூடியூப் லிங்க் உள்ள கொடுத்துருக்கேன், அது மாறிடுது. இப்போ இது இதுங்களா இது
லைவ்ல இருக்கு? ஆமாம் சார்.
ஓகே. இப்போ இது கொஞ்சம் இன்க்ளைனாக வச்சுக்கலாமா இதை?
சரி சார்.
ஸ்பீக்கர் ஓகே அப்படியே இருக்கணும். இப்போ அவருக்கு நான்
சார் விஷயம் சொல்லுங்களா?
சாரையா ரைட் கூப்பிடுங்க.
செக் பண்ணியிருக்கீங்க. இல்லை சார், இது பண்ண சொல்லுங்கள். லைவ் ஸ்ட்ரீமிங் செக்கிங் பண்ணிக்கலாம். நீங்கள் சார் நீங்கள் போங்க. நீங்கள் போங்க, போயிட்டு யூடியூப் லிங்க் ஓப்பன் பண்ண சொல்லுங்கள். மீண்டும் ஒரு லிங்க் ஓப்பன் பண்ண சொல்லுங்கள். நான் இருக்கேன். அது ஆன் பண்ண சொன்னால் ஆன் பண்ண யார்
இவர் ஸ்பீக்கர்
அது லாஸ்ட் கனெக்ட் பண்ணல. கனெக்ட் பண்ணுங்க. Hello, sir. சார் எங்க இருக்கீங்க நீங்க சார்
சார் சொல்லுங்க ஸ்டார்ட் பண்ணுங்க
ஸ்டார்ட் பண்ணுங்க
Okay, warm greetings from RAJALAKSHMI Engineering College and a very good morning to the Chivalry's crowd. I am extremely overwhelmed to have you all for the National Joint Online Program on Intellectual Property Rights, Patents and Design Filling, which is jointly organized by the RGNIIPM and IPR. The main objective of today's event is to create an awareness on the student community on intellectual property rights and patent. Now I would like to introduce our beloved chief guest, Dr. Bharat N. Suryavamshi.
He has been working under the central government patent office, Ministry of Common and Industry too, of more than 18 years now, and it is assistant controller of the
Now about our chief guest, Akash will introduce about the chief guest. சொல்றது புரியுதுங்களா? பார்த்தெல்லாம் மாறி மாறி சொல்லுங்க. என்ன சொல்றீங்க? அதை மட்டும் கொஞ்சம் பார்ப்போம். சரியா?
All students are expected to keep their microphones on mute unless instructed by the person in charge to do otherwise. Q&A sessions will be held at the end of the program. For any technical discomfort caused and if any help is required, kindly use the raise hand option and keep us posted on the chat box. Any unnecessary messages or disobedience will not be entertained and the participant will be removed from the meeting. Kindly stick on to the norms and help the volunteers to conduct the program with ease. Thank you. Warm greetings from Rajalakshmi Engineering College. I am extremely overwhelmed to welcome you all for the National Joint Online Program on the Intellectual Property Rights, Patents and Design Filling, which is jointly organized by the RGNIIPM and NIPM. The main objective of today's event is to create an awareness in the student community on the intellectual property rights patent. Now, I would like Akash to introduce the chief guest.
Our beloved chief guest, Dr. Bharat N. Suryavamsi, has been working under Central Government Patent Officer, Ministry of Commerce and Industry for more than 18 years as the Assistant Controller of Patent and Design. He has completed his PhD from Swaminathan and Tirth Mathwada University at Maharashtra. Profiled proteolytic lactic acid bacteria from Gulbari University, Karnataka. He has completed his PG in biotechnology in the same university. He has published various research papers for both national and international. He has also delivered many lectures on IPR in various parts of the country. He has also debuted for training at Tokyo and Japan on examination of IPR issue. He has also given landmark decision by rejecting Pfizer patent application for Athist drug, which was filed in India 2015. Warm welcome, sir. Kindly take over.
Thank you so much. I also welcome you all for the IPR session. Most of the people are aware of the IPR. The students may not, even though I'll throw some lights on the IPR by sharing my slides. Are you able to see my screen?
Yes, sir. Yes, sir. Yes, sir.
Yeah. First of all, I introduce my office where I am working. I work under the Office of Control General of Patents, Designs, Trademark and Geographical Indication. As you might are knowing, we are having different patent offices at different locations like Kolkata, New Delhi, Mumbai and Chennai. We are having training center at Nagpur that is called PIS, Patent Information System. Now it is renamed as Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. We are having trademark offices in addition to 4, one is at Ahmedabad. Again, Geographical Indication Office at Chennai. These are the pictorial view of our offices: Mumbai, Delhi, Chennai and Kolkata. This is our training center. This is our website. We are conducting many more programs. This is an awareness program. I cannot go in detail. If you want to be more perfect or you want to know more programs, please see our website as well as social media accounts like Facebook and Twitter and join the programs and be perfect in the IPR. Let us see today's topic, what is intellectual property? You can see I have shown something blooming in the mind. It means I want to convey that the product of mind is called intellectual property. For example, today you are being engineers thinking to bring new technology in the market. If somebody is from computer science thinking to give digital mosquito catching device, there are many mosquito catching devices are in the market, in the public domain, but you are supposed to thinking to give and digital. If that digital mosquito catching device is having combination of hardware and software which can recognize human hand and mosquito. If I am bringing my hand to the device, it never gives shock to me. But if mosquito passes, it gives shock to that. It's a digital way. So it's a new idea which is originally from your mind is called intellectual property. I'll give another simple example. Day by day, we are knowing in the newspaper that petrol, diesel rates are getting higher. Somebody is from chemical engineer or biotechnology or microbiology thinking to give biodiesel. It's a renewable source of energy. petrol, diesel or not. So you are trying to give permanent solution for the diesel and petrol. So that idea, how it comes, that's an intellectual property. If it comes in the form of product or process of production of biodiesel, it's again intellectual. I'll quote another example to make you more clear that somebody is thinking to give new device for the production of beverages. It's a mechanical engineer work. If he is a mechanical engineer developing a new device to produce beverages, it's again intellectual. In December 2019, we heard about the coronavirus. At that time, we are not having any vaccine for that, but scientists all over the world started to know about what is coronavirus. They thought, they carried out the research and they came up with Covaxin, Covishield, Sputnik. What is this? It's an intellectual property which arises from our mind. Therefore, intellectual property in simple way, we can say the product of mind is called intellectual property. How it arises? During discussion in the classroom or even the lab carrying out research or with professors or sitting alone and a group of people and thinking to solve some problem and you are developing some idea. Therefore, intellectual property that arises from human intellect, what is a product of human creation. For example, now we are having bikes which run on electricity, four-wheelers which run on electricity. If you are developing device or a vehicle which run on hydrogen fuel or water, it's again intellectual. Or we are thinking to produce biogas from your campus waste, again it's an intellectual. Something new you are trying to do, that's called intellectual. Let us see what is the background of intellectual property. Property means our mind directly goes to the tangible form of property that we say, I am having car, gold, plot, flat, so I am rich enough. But there is another kind of intellectual property called as intangible form of property, that is intellectual property. That is industrial property and corporate. Wherein industrial property includes patents, designs, trademark and geographical indications. How to define intellectual property? If the definition comes, intangible creations of whom? Human intellect, because all is product of human mind. Again, it's having commercial value, asset like any other form of property. Don't think that if you are having gold, flat at Chennai, going on the rent and thinking that I am having property. Even if you are developing biodiesel, as I told you, any company like Reliance, HP, Bharat can approach you for licensing, you can get money out of that. Therefore, it's an asset like any other form of property. There are different intellectual property rights. If you are developing new technology, filing patents, then right is with you. Only you can exercise the power of that, not your brother, sister, nor a teacher. Therefore, it also called as a negative. Again, IP is an territorial right. Once you are developing new technology, filing in India, you are protecting India only. If you want to establish your market in other countries like USA, Japan, Germany, you are supposed to file your application in those countries. Then only you are getting the protection. Otherwise, anyone in another country can use your invention. Therefore, keep in mind that patent or IP is an territorial rights. It's a licensable right. It means if you are developing some new device, new technology, you can license to any company with the royalty, what year you are charging for that. For example, if Bharat Biotech of Hyderabad is developing Omicron vaccine composition, they can assign their right or license their right to the Biocon of Bangalore also, and they can start production. What is patent? Exclusive, monopoly privilege or right granted by the government to the patentee for 20 years from the date of filing or guarantee for commercial gain in consideration of the full disclosure of its invention as a territorial right not. It means whatever you are doing invention, you have tried clearly, then only government of India is giving 20 years right. For what? For commercial benefit, not to keep a file record to get a promotion as a principal or professor. It has to work and fulfill the requirement of it's an asset like any other form of property, and this only territorial right, not worldwide.
Hello, sir.
Yes.
Sir, I have a doubt, sir.
Yes, please.
Sir, if a person is creating a new thing and he's getting a patent, a different person from another country is creating the same thing with his idea. The both ideas are same, sir. But
Okay.
how the patent will be get, sir?
See, whoever files the first, that person get the patent for that. Okay.
Sir?
For example, same, though both the persons are inventing same thing, they are filing the patent. Who has filed the first? He is getting the patent for that.
Okay,
You are
sir.
filing,
Sir.
so you will get the patent, because once we are searching, we will come to know who has filed, who has prior claim. You are the prior claim. Your first claim
Yes, sir.
before him, so you are getting for that.
Yes, sir. If we forget to just create a pattern, the other person will get our idea, right, sir?
Yes. Yes. Okay.
Okay,
So
sir.
always keep in mind, if you are filing your patent application, we count your time in seconds, minute also, and you are first claiming, means you are first filed, so you are getting the right for that. Okay.
Okay, sir. Thank you, sir.
So many people while doing their project or research, they don't know whether they are doing discoveries or inventions. So first of all, we should know what is invention and discovery. Discovery means finding or exploring something which already exists in the nation, and discovery as such no technical level. For example, I know some cement industry is having some bacteria, jute industry having some bacteria, medicine industry also. I know, but I am taking project at isolation of microorganism from cement industry. The microorganism what I am isolating is a discovery. But genetically, if I am modifying using genetic engineering technology, that's again new, because genetically modified microorganism human intervention. So that's an invention. We know periodic table. Somebody is isolating new metal or element, then it's a discovery. But the process of isolation of the metal or element is an, if it is new, it's an invention. So we should understand while carrying out research or a project, are you doing inventions or discoveries? If it is invention, please go for the patent filing. How your project topic or your product is qualifying the definition of invention. Invention means new product or process. Product means ATM machine, CT scan machine, furnace or medicine composition, medicine association product. Process of preparation of so and so is a process. Again, it should be useful to all. It should be something new, non-based, and it should not be the public knowledge before the filing date. Then definitely you are qualifying the definition of invention. Even for the paper publication, what we do, we check whether my research work is published in international, national, or any local journal or paper. If not, then only we are publishing. Same way, if you want to say that your invention, then it should qualify the definition of novelty, non-obviousness, it should not be the public knowledge. Simple example is a sharpener. Earlier there was no sharpener to sharpen the pencil. People used to use the blade for sharpening that. But somebody has invented, because first time they are bringing technology, therefore invented. C.A. Bush. He has not given the word sharpener. He told tool. You know, you are from institute, engineering college. Tool means something big machine. Tool for sharpening a pencil, writing point by saving of its own surface. Again, in the general knowledge we have studied who has invented electric bulb, who has invented aeroplane, who has invented vaccines. We know all because in the school level we have studied. Like AG bell is for the telephone. As though we have connected virtually, we can make this session as an interactive. Can anyone tell me this technology of AG bell was in the market in the year 1876, even though the scientists of electronic and telecommunication or computer engineers thought of giving mobile phones in the public. What was the necessary? Why they thought to give the mobile phone in the public? Anyone please? Professors, students? Until unless we think innovative, we cannot get something new idea. So how someone got an idea to develop a mobile phone in the world? Somebody has invented telephone.
Yes, sir. Sir, it is an interesting idea.
Yeah.
to create awareness and to create a new thing. People will just see like the mobile phone is like a wonderful thing, sir, because they don't saw anything like that, and it is a new thing. So it developed a lot and it gave more money for companies.
Any other idea? Anyone? Anyone? See, first of all, you might have seen in the old movies of all the languages, this telephone is having some disadvantage. What is that? I cannot change this telephone from my cabin to my principal's cabin or my colleague's cabin because it's connected at a particular point where I have to speak. If your phone comes, you have to run to my cabin, then you have to speak. Again, it takes 10 times I have dialed, ring, 10 times I have dialed, very hectic and time consuming. To overcome that, somebody thought to solve the problem and they came with the table phone wherein I can dial directly on the buttons, but again, I cannot change from my cabin to my principal's cabin. To overcome that, we got cordless phone, which was long, we can take in the hall, kitchen and drawing room, but we cannot take in the meeting, nor in the jail, nor in the car, nor in the bus, nor in the train. To overcome that, somebody thought we got the mobile phones in India in the year 2002 or 3. If you remember, simple Nokia of silver color was more than 5,000 rupees. Now, 1,000, 2,000 up to 40,000. Again, only incoming and outgoing were there. Again, improvement, we got video calling facility. Again, improvement, we are having Webexlink, Google Meet, this Meet, that Meet, and we are speaking to each other. What is this? Improvement of technology from AG bell to mobile phone. So I want to convey one message that don't think that to get a patent something great you are supposed to do. Even improvement in your own field, even improvement in your own technology, if you are physics, mechanical, electrical, electronics, depend upon a field, you can do improvement in the devices process, you can get the patent for that. Like AG Bell has developed, but Nokia, Samsung, Reliance, Apple all got patent for their technology. I'll quote another example for the non-engineering side people. For example, we know paracetamol. If you are having tablet paracetamol, if you are having fever, you are taking at 8 o'clock after the breakfast. It takes 6 to 8 hours to reduce your fever. Somebody comes with improved composition of paracetamol which can reduce your fever within 1 hour. What is this? Improvement in the result. Technology. You can get patent for that paracetamol composition also. Because paracetamol which is available in the market is taking 6 hours to reduce your fever, wherein my tablet is reducing fever within 1 hour. What is this? Improvement in the efficacy. So, any improvement in the technology also you can get the patent for that. Earlier there was no Bluetooth, but someone has invented, and that is Jaffer's. Vaccines, nano cars, what is this? These are the examples of inventions. Smart car, drones are the examples of inventions. Let us see another kind of intellectual property called designs. Design means shape, configuration, pattern, ornament, or composition of lines or color combination thereof applied to any article in the form of 2D, 3D, or both forms. I have taken the example of Bajaj iron box. You can check if you are having iron box in the home, the design is totally different. I am having water jug of this Milton company and the design is like this. You can check your mobile. My pen design is like this. My Dell computer, you might have some other computer. My mobile is of Nokia, you might have Samsung or Reliance or Apple. See the design. Mine is HP printer, you might have some other company. The design is different. So, anything which looks beautiful, that's plus design. Mobile design, brush designs, car design, even handle design is also different. Mere functional or technical feature of the article are not considered design. How it works, that's how it functions, that's an technology, that's an patent. But how it looks, that's an design. Term is 10 years. It can be renewed every 10 years subject to the usage. Even set of articles also you can register. Set of articles. Cup set, sofa set, chair set, spoon set is also registered. Sanitizing machine, new design. If you take other fields, like. If you take other fields like ampoules, this ampoule design is different from this ampoule, this ampoule. This series is different from this capsule is from this. So anything which looks beautiful, that's an design. Anything. If it is new, you can go for the registration of the designs as well as. Again, if you go to textile and jewelry, you can check the design stuff. Curtains, bed sheets, earrings, bangle, watches, all the designs are different. Therefore, pattern design will not be copied by the Timex or any other design of textile company also. Even daily consumer products like bag, water bottle, aquaguard, aquafine, your sanitizer bottle. This iron box is from this. My wallet is different from this wallet. Mine is like this. This scope is different from others. Whirlpool, LG fridge, IFB washing machine. The designs are different. So anything which looks beautiful, you can go for the rest. Even shape, configuration, pattern, ornament of the buttons. You can check this surface button, this all are different. Even this one, Tom and Jerry facing this. Again, this one, pencils we know, but pick up and correct is something. Again, shocking. All the designs are different. Again, example of technology, Garrett A. Morgan developed the signal system. While passing on the road, he saw a terrible accident and he thought how to prevent that. What we do, we make them to reach the hospital or we give them a bottle. But he thought how can I prevent? He has given a solution for that technical problem. Therefore, inventions makes our lives safer. Different designs you can check. Again, this type of design is developed by one of the students of National Institute of Design, Ahmedabad. Can anyone tell me how that fellow might have got this idea to develop such kind of designs? Why can't you and me get an idea to develop such kind of designs? During final year of BSc, MSc, we are supposed to do the project. While doing the project, we should do something new. Then you can register under section. If it is design, if it is scientific, then project. You can go for that. He thought something new design he is supposed to do. So he thought that he can develop something new design. So he went to the construction companies. He talked with many of the coolies who are working there and he has brought this solution. They complained that they are getting neurological disorders by carrying stones, bricks, sand on their head. So he has given solution to that problem. It is not touched to head, it is above the head, where it is distributing throughout the body. Here it's not sponges, so it's not giving directly. This weight is throughout distributed, not directly on the head. So there was a problem. He has given solution for that same new design. If you think innovatively in any kind of field, definitely you can do new design for it. Even you can get protection for semiconductor, integrated circuits, layout design as one of the intellectual. You know, SICs are fabricated from a complex series of layers of semiconductors, metals and diodes. These should be original, distinctive, capable of being distinguished from any other layout design and have not been commercially exploited anywhere else. Then definitely you can go for the registration of this semiconductor integrated circuit under the government of India and can be protected. Term is 10 years from the date of application, filing on first commercial exploitation whichever is early. Let us see another kind of intellectual property called trademark or brand name. You know visual symbol, which may be word, name, brand, numerical or combination of colors indicate the source of the good, the distinct of the other goods like Tata, Bata, Reliance. What is this? Name itself indicates which company it is. It's a brand value. It advertises goods and services, protect the innocent public from buying the goods of secondary public. R with encircle is a registered trademark. TM is trademark applied for. Duration is 10 years. It can be renewed every 10 years subject to the usage. There are different trademarks, trade names, collective marks, certification marks, taglines, slogans, and so on. McDonald's, Adidas, Google, Dil Mange More, Bureau of Indian Standards. All these are different kind of trademarks. Another kind of intellectual property called geographical indication. Place names used to identify source of origin, quality, reputation, or other kinds of products like Darjeeling tea, Kanchipuram silk saree, Kolhapuri chappi, Agra petha, Nagpur orange. These are the different kind of geographical indications. Makrana marble of Rajasthan, Ratlavisi of Madhya Pradesh, Katputli of Rajasthan, Bagh prints of Madhya Pradesh, Bengali Patispara, many more. Even in agriculture products like Magai pan, Devanali Pamelu, Apimidi mango, Kashmiri saffron, Sahilicha Bihar, Kurg oranges. These are the different kind of agriculture products. Again, GM. Let us see another kind of intellectual property called copyright. Provides holder right to restrict unauthorized copying and reproduction of an original expression, literary work, movie, music, painting, software. The term of protection is life of the author plus 60 years. Therefore, you might have heard many singers are not no more, but still they are getting the royalty. The books which you are referring may not be the author, but still they are getting the royalty for that. If you are writing books, novels, stories, autobiographies, or poems, it can be registered under literary works of the copyright. If you are doing artistic work under section 2, dramatic works under section 2, musical works under section 2, sound recordings under section 2XX, cinematography films under section 2. Means each kind of work is getting protection to copyright. If you are computer science, plain software as such you can go for the copyright. But software with the combination of hardware like ATM machine, mobile, you can go for the patent. The simple example I have taken to make you understand. The symbol is a trademark, Apple. LED display technology is a patent. Body of laptop is a design. User manual, you can get copyright for that. Layout of internal circuit, this one you can get protection under SIC. So each work you can get protection so that the Apple laptop cannot be copied by the any other company laptop technology like Nokia, Samsung, Reliance, Lenovo. They got patent, designs, trademark, and trademark also. So that other company never copied it. Apple never copied the technology of Nokia or Samsung or Reliance. Reliance never copied the technology of Apple or another company. Each got protection. Therefore, they are playing in the market. Independently, they are in the market. What are the career opportunities for the students who are listening my lecture? If you are any branch of B, MSc in chemistry, biotechnology, microphysics, you can become an examiner of patent and design in the government of India. There are two papers. One is objective, another descriptive. If you qualify, you will get job in the government of India. If you are having law background, you can become examiner of trademark and GIS or examiner of copyright also. If you are any science graduate, BSc, you can become patent agent. Every year we call for the patent agent examination. This shall also be already called examination in the month of May. There are two papers. One is objective and the descriptive. Then Viva. If you qualify, you get patent agent number from the government of India and practice it. You can work as an GRF, SRF, as patent facility centers. You can work in the patent litigation also. You can work in the IPR policy, RPR cell of central government, state government, MNC company, even institute, even in the institute. You can work in the NGOs. Or there are many IPR firms in big cities like Chennai, Bangalore, Pune, Mumbai, Delhi, many more places. Then you can work in the IPR firm also. Even you are a scientist. You might have done many research. You might have awarded PhDs. You may be faculty in fields. You can also become an inventor. Inventor means something who brings new technology and patent is awarded on this. By simple approach. While carrying out research, identify some problem. Solve that problem, definitely you can get the patent. For example, if you are a computer science fellow, you can develop a device which can give SMS alert to a farmer when his wild animals are entering his field. SMS alert, once water tank is full, you are getting alarm that water tank is filled. Why can't you give SMS alert to a farmer? Or During puja, Ganpati puja, Durga puja, or any Devi puja, any puja, what we are doing? We are bringing many flowers, garlands, and Navidyam. After puja, we are throwing some pond, river, lakes. What we are doing? We are polluting the aquatic life. Once government come to know, they throw some chemicals. It is affecting the aquatic life of that pond, river, lakes. If you are bringing biological method for treatment of pond water, it's a solution to a technical problem. Or if you are developing a device which can purify the filter, or a nostril filters which can purify the air. Many problems are there. If you solve, definitely you can get patent for that. Or herbal composition for cancer. There is no herbal treatment for the cancer. If you give in India, you can get patent for the all process drugs, but they should be new. They should have inventive step and capable of industrial application. If you check section 3 and 4, it's a non-patentable inventions in India, like method of treatment, plant as such, animal as such, method of presentation, many more are there. You can check section 3 and 4 in detail. Product includes apparatus, device, machines in chemical products are patentable in India. How we can say that your project or research is new? It should not be published in India or elsewhere throughout the world. We check for the novelty. It should not be in the prior public knowledge or prior public use within India, or it should not be claimed before in any specific India or elsewhere. Definitely then your invention is new, you can go for the patent filing. It is qualifying the definition of novelty. Now, how we can say that you are qualifying the definition of inventive step to get the patent? What is inventive step? Feature of invention that involves technical advancement as compared to the existing knowledge. As I told you, AG bell to mobile phone. What is the gap? Technical advancement. Or having economic significance. Earlier Nokia mobile, simple Nokia mobile is more than 5,000 now, 500,000. What is this? Economic significance. Or both. And that makes invention not obvious to you, person skill in that. What is obviousness? Making dosa is very obvious to all. Making tea is very obvious to all. But to get a patent, it should not be obvious. It should require some experimental skill. Now, who is the person skill in that? For example, my patent or my invention is a digital mosquito catching device. Any computer science fellow is the person skill in that. If my invention relates to an herbal medicine for cancer, then any botany fellow, biotech fellow, or pharma fellow is the person skill in that. If my invention relates to a device which convert solar engine to electricity, then any mechanical person is a person skill in that. So, depend upon the field, the person skill in that should not feel that it's an obvious invention to get into. Therefore, to get and qualify the invention, technical advancement, economic significance, and it should not be obvious to a person skill in that. To fulfill this inventive step, something surprising result you should get. Solution to a long-standing problem or fulfillment of a long-felt need or a great technical progress you are supposed to do, then definitely you are getting the patent for that. Again, another requirement should be made or used in the industry. If you are developing a project, you know how to write. But if you are writing patent application, you don't know how to write. The essential ingredients of the complete application while writing the patent application, you should have title and field. What is title? Herbal medicine for cancer treatment or digital mosquito catching device is my title for my invention. What is the object of the invention? Earlier there are many allopathic chemotherapy treatment, very side effects, so I am giving herbal treatment. What were the drawback of that? What efforts you are putting? Summary of the invention, statement, detailed explanation, clinical trials, examples, then finally you have to claim statement. If it is mechanical, electronics, you have drawings, you have to do the drawings also. In biotechnology, sequence system, you have to give in detail. There are two types of claims. One is called independent claim, another is called multiple dependent claim. For example, process of preparation of herbal tea comprising steps of A, B, C, D. A, taking cup of water, comma, allowing it to boil, comma, adding cup of milk, comma, adding sugar and tea powder as per the taste, boiling and filtering. My tea is ready, full stop. Dependent claim means process as claimed claimant, wherein One of the ingredients is ginger in my tea, additional feature. Process as claimed to wherein another ingredient is cardamom in my tea. These are the multiple differences. You are defining additional feature or the feature of claim. Now, how to file your patent application in India? Who can file? Anyone, any person, natural, startup, MSME, anyone can file the patent application. There is no age bar limit nor educational limit because invention can be done any point of view. There is no age bar limit. Physically, you can go to your jurisdiction, your Chennai, or online by sitting in your own lab house. You can file as you have given the facility since July 20, 2007. There are different jurisdictions as you was in Chennai. So, state of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Pondicherry can go for the Chennai. Other states depend upon that. What are the minimum documents required for that? Covering letter indicating the list of documents. Application form 1. Proof of right means we have to sign paragraph 9 of the form 1. So they are declaring that we are the true and first inventor for this invention. We are filing provisional or complete form 2. Provisional means once today you are getting the idea, same day you are filing, that is called provisional. Complete means after complete research with the claims you are filing, that is called complete. Statement of foreign filing, form 3. Means which country you are filing, same invention. What is the status in that country you have to mention in form 3. Form 5 is for declaration of inventors. Means as I am from mechanical branch, I am adding my friend name of who is electronics, who is computer science. So I can add here, but keep in mind that everyone will get equal rights once your product is commercialized. You have to share equal benefits. So please think, really those who are helping you, their name only you can add in the form 5. Request for examination should be done on form 18. Until unless you request, we never examine your application. Pitch in the form of DD or check physical. If you are paying online, pay the fees online. Fee structure is already given in the website. Please see carefully. Even though online filing fees for natural person is individual is 1,600 per company, 8,000 for others, up to 30 pages. Per page for individual 160, company 800. More than 10 claims 320 for individual, 1,600 for the company. If you are doing hard copy, 10% in addition to the fees what I have mentioned here. Again, if you are having chance to file the expedite examination as per Rule 24B, means you can request for fast examination. Within 1 year, you can get the penny for that. For that, Form 18A is required. And who can file the request for that? For example, if you are choosing or filing PCT, Patent Opportunity, in that if you are choosing India as an international searching authority or international preliminary examination authority, then or applicant is a startup or as per the rule, one of the applicant ladies in a group or government organization or institutional request for the Form 18A. Fee is 8,000 for individual, 60,000 for the company. Now, this is our website. If you want to know about the patents, please click here. You can get all details of the patents. If you want to design, go here. Trademark, go here. GI, now programs here. If you want to file online, comprehensive e-filing, you should require e-signature or digital signature. If you want to search, your topic is new or not. Public search, go by title search, publication search, name search, depend upon that. Now, how we are granting the patents in English? Yes.
Sir, I have a doubt, sir.
Yes, please. Yes.
Sir, you told about Apple products, right, sir? They get a patent and copyrights
Yes.
of that logo and of the software, sir. Sir, I think
Yes.
Steve Jobs created this company and he launched the product and he got a patent, right, sir?
Okay.
After that, sir, he's a partner of the company, sir. With him,
Okay.
another person is there. He is spending financially for that company to get a product. Ideas is Steve Jobs and the product and the amount is that another person, sir.
Yes.
Now the
yes,
fact
yes.
is, after one time, that partner told Steve Jobs to go outside of the company, sir, because of the share problem. After the same person, after some years, he called that Steve Jobs back, sir, I just have that curiosity that whether the person, Steve Jobs got a patent of that product, so he can't able to launch in that company. It may be
See.
affect the company, sir.
Yeah, see, first of all, what happened, whenever you are offering job in any company, they do an agreement. You have to sign one agreement. What the agreement is
Okay,
that
sir.
whatever invention are evolved from my company, when you are working in my company, all the applicant is the name of the company like Samsung or Apple. Okay? Because you are signing the
Okay, sir.
agreement. Whatever you are doing research in that company, utilizing the resource of that company, the invention lies with the name of the applicant agent, that company. You are the only inventor and you are assigning your right in column 9 of form on that. Whatever I am doing is right, is I am giving to the my company, that's Apple, Samsung, any company. So if company wants, they can share you the benefit of that product if they wish. Otherwise, they are paying for you. So there is no criteria that they can pay you separately because they have been given you the employment. You have signed the agreement. Therefore, all the rights with the company only. That's
Okay,
depend
sir.
upon the agreement you have made. Any disputes come,
Okay, sir.
then any dispute come, you cannot come in the way of opposition. I'll tell you later now in this field, in this section we are having opposition, how they can come. Okay, he cannot
Okay,
come
sir.
as an opponent because already he has given signature that I am agreed with your condition. Whatever I am inventing, whatever new I am getting in your company, that lies with you only. I am just working, I am getting payment for that. So all this agreement depend upon, if you are not making any agreement, then once you are leaving your company or the company is throwing you out, then you can come as an opponent. Means you can oppose that it's my patent, he is claiming like that. So depend upon the conditions, how you have been employed in that particular company, what agreement was been signed by you, that matters a lot. Okay.
Okay, sir. Okay, sir.
Now I'll tell you how we can oppose here. For example, once
Okay,
you are
sir.
filing a patent application, we first digitize it, we screen and classify which it is mechanical, electrical, electronics, physics, biotech, micro, which field it is, we classify by using international patent class system. In that, if you are requesting for early publication, we publish within week or a month, otherwise 18-month publication. Once it publishes, anyone can oppose as a pre-grant opposition. Anyone, for example, you are from mechanical, you develop one device for production of raw alcohol from sugar molasses. Then another company of mechanical can oppose you. No, this device is not new. Already is published in some paper, some journals or some book. You can oppose. Anyone can. No problem that. So we deal with that. Opponent's grounds are forwarded to the applicant. He has to reply for that. If you are requesting for the examination within 48 months, it's go for the allotment. Then examiner will examine the case, make the report on that, pass to the controller again examine, they give the report. It's called first examination report, FER. You have to reply within 6 months. If you are unable to reply, you can take extension of 3 months. Within 9 months, by hook or crook, you have to reply for our first exam report. If you are not replying, it will be abandoned. If you are replying, reply is okay, persuasive, then patent is granted on the same day. If your reply is not okay, you will get chance of hearing or second exam report. You can come to our office or video calling facility. You have to make a certificate that your technology, what you develop, is new as compared to the other technology. Once you have made satisfaction, then we go for the grant. Otherwise, we reject it. If you are granting or rejecting, we give the speaking order so that you can appeal in the higher courts also against our orders. Once it's granted, it's go for the post-grant publication. Within 1 year from the date of post-grant publication, only interested person can oppose. Starting, I told you, anyone can oppose. After grant, only interested person. Now, who is the person interested? For example, Hyundai companies develop some new engine, then Maruti Suzuki, Tata Motors, Mahindra can oppose because they are involved in the same business. Therefore, they are called as person interested. Once they filed opposition, we constitute an opposition board inside the office. 3 officers, one is chairman, 2 are the member of that board. They give recommendation on the opposition board. Simultaneously, opponent's grounds are forwarded to the applicant. Applicant has to give detailed reply on each ground. The reply issued from the applicant again forwarded to the opponent. He give reply in that. If applicant or opponent request for the hearing, that is called post-grant hearing, we fix the date, that is called post-grant hearing date. Their applicant, their lawyer's agent will appear. Opponent, their lawyer's agent will appear. We at the table like a court hearing, we discuss each ground of opponent with the applicant. If applicant is able to overcome all the grounds of opponent, definitely be granted. If applicant fails to overcome the opponent's ground, definitely rejected. If you are granting or rejecting, again we are giving the speaking order so that you can appeal in the higher courts. This is the way of granting the patents in India. Now, for example, if you are developing design, how we can find? As per section 544, rule 11, you can file the design. If you are a natural person, 1000 rupees fees. Small entity, 1000. Startup, 1000. Other than that, 4000 fees for joining, filing that. In that form 1, you have to fill applicant's name, nationality, address, which class of your design is, private data, 2 set of written receipts, power of attorney if you are going through lawyer, agent, prior document if you are having, assignment if you are having, if you are startup or MSc, Form 24 is required for that. We classify your design by using Locarno classification system of version 13. There are 32 classes, 237 subclasses. Like, for example, if you are developing in medical and laboratory equipment, class 24. If you are developing pharmaceutical product, class 28. Foodstuff, class 1. So, which class is article you have to mention? You have to write statement of novelty with your design. For example, I developed this and new design. So I have to write how my design is new. I'll give the example further. This is my new design of a teapot. Name of the applicant, your Institute of Engineering, so and so. Total number of sheets are 10, 1 of 10, 2 of 10. You have to give each clean sheet or clear sheet of drawing. The novelty resides in shape and configuration of this teapot illustrated. No claim is made by virtue of this registration in respect of mechanical or other action. How it looks, that's my design. Name of the applicant if you are filing, if agent or lawyer, they can sign. These are the bad quality of the design. What is the rule of patent system? Encouragement or improvement of technology. Because of patents, we are X-ray to CT scan, eligible to mobile. Day by day, we are getting improvement. Providing reward as an exclusive rate for disclosure. If you are doing something new, disclosing, government is giving reward. Making profit or earning royalty through putting the invention to practice. Don't keep in the file record. Let it work, then you can earn from that. Transferring to public property after expiry after once 20 years old, it is in the public domain. Or you are getting the patent but unable to pay the renewal fee, it will be seized, then anyone can use your patent application. What to do now? You came to know about the different intellectual property rights, how to write, how to file, what is the patent granting procedure, even importance of IPR. So, don't wait. Patent system in school, colleges, universities. Utilize the resource through organized R&D activities. Capture the global market judicially, earn the profit through the protected market only. Otherwise, somebody will file before you, like Samsung, Sony TV. Both are TVs, they are in the market, but independently they got patent designs for the technology. Therefore, they cannot copy each other technology. So, you also protect, then come in the market. Thank you.
Thank you, sir, for the valuable information. I'm sure you have helped a lot of us understand more about this. It will create a great impact. Thank you, sir. The participants can now raise questions and ask their doubts on the session.
Sir, please circulate the feedback link which I have given to you so that they can get the certificate.
Hello, sir.
Okay, sir.
Yes. Yes, please. Go ahead.
Yes, sir. Sir, for example, before some years they created a microscope, sir. Nowadays they created digital microscope, sir. There is an upgrade in that. For that also we can get a patent, right, sir?
What I told you, if you are doing any upgradation, what is the improvement in the technology, you are getting good results, or what it's showing, that is called inventive step. How you are proving, that is left to you. The burden of proof is lies on the, if you are proving, definitely you can.
Okay, sir. Sir, if I have an idea, after that I can get a patent, or if I should create that idea as a project, and after getting the useful of everything, after that I should get a patent, sir.
See, first of all, once you are getting the idea, you can decide whether my product is having something new, it's having value. If it is really your thing that is value, then go for the provisional filing. Means you are getting idea, same day to save the priority, write on some papers, file that your idea. Within 12 months from that idea, you have to complete your whole research with the claims, you have to file, that is called complete application. It's left to you. We are not asking you the prototype, whether it is ready or not, but overall concept is ready. If you are claiming, then definitely you can go for the complete patent application.
Okay, sir. Sir, you told about that, like designing, right, sir? Designing of like a products, like a pen, like it
Yes,
should
any
design
design,
and
any design.
any design which should have upgrade or which should be liked by all.
It should be new, something new than what is there in the public domain. I am having Ketan fan also, Bajaj fan, both are registered one. I am having LG fridge also, again Whirlpool, both designs are already registered. So how it looks, that's a design. I have shown you many examples of pharma, daily using products like Valet, Coma also. Something new, if it is not in the public domain, you can go for the design registration.
Okay, sir.
Please fill the feedback link for the certificates, circulate among all so that they can get the certificate. I am not responsible if you are not filling this link. Any other doubts?
We apply for copyright, we can't get the patent.
See, copyright is different from patent, and copyright is very easy to file. For example, if you are developing software as such, then go to the copyright website, log in, create your ID, password, fill the form, upload the software whatever you are developing. Or if you return the books, then upload in the PDF form. Within 30 days you will get reply for that. If it is okay, it will be granted, means register. Otherwise, you will get an objection, you have to reply for that. But in trademark, you should have a digital signature. For design, you should have digital signature. For patent, digital or e-signature. But in copyright, nothing is digital. Just log in, create your ID, password, then fill the form, upload the document, pay the fees online if you are filing online.
Sir?
Any other doubt?
Sir, am I audible?
Yes, you are audible, ma'am.
Sir, I have a doubt regarding I have a device developed. So,
Okay.
for the patency, if I apply, should it be an idea patency or the design patency kind of thing or entire periodic?
See, if your idea, what type of idea is? For example, my idea is to produce by design. Technology you can apply for the process of production of my design and patent. So developing some design for my this one, so you can apply for the design. So
If I develop a healthcare device, sir, healthcare
Then that's-
technology is already in
Yes.
in practice, but it is not
Yes, if
a
it is a-
device, a portable kind of device, as you have told like
Yes.
the telephone example. It is not a
Yeah.
portable device. So I am planning to implement the idea that is existing in US or other countries, but not in India. And implementing the idea to my device where the device is new to the market. So what kind of patency should I go for?
For example, first of all, if that device idea is already using in the US EP, you will not get patent for that. You can go, if it is new design, you can go for design. But totally your device is new, combination of software, hardware, or simply new design like a mechanical design. If it is construction feature are new, you can go for the patent as well as designers. For example, ATM machine, CT scan machine, BP measuring machine. You can go for the patent also, you can go for the design if it's something new. What the idea, ma'am?
Okay, so if my idea is new, but the device manufacturing and things are new, I can go for patency, right?
Yes, yes. How it works,
But
that's
also
it.
the patency,
Because
but
many,
then
many design many devices are in the market, but everyone getting see Samsung, Sony also got patent, even that another TVs also got the technology, because how it is different from that we have to prove.
Okay, sir. Sir, also one more doubt regarding forms. So we have been filing patents here. So for the form 3, should the applicant name be the students or the college? How does that
See,
function, sir, if a college student
for
applies for
example,
patents?
if you are filing our application for patent, first, if your college is permitted to file on your name, you can file on your name with your guide or your sir also, or directly you can file your college name. It is left to you, it is your own decision. In company, what happens, company will not provide
If I
right to
submit as a college
the
name,
employee.
will that patency be under my name or the college name? How does
It
that
is
function, sir?
it is depend upon you. If you are putting in column 1, I the applicant your name, then it is like with you. If you are putting your college name, it is depend upon you whom you are giving the application. But inventor, you are the definitely, because you are creating the idea or product. So you are the inventor for that. Applicant left to you. You can put your college name or your colleague's name or your friend's name also. How much name you want to, that is left to you.
Should the applicant name be one or many? Can it be many?
Yes, one or many. The no restriction
But
at all.
in form 3, they have given like only one space for the name of the applicant.
No, you can create, if one, you can create, put comma and put another name, 1, 2, 3. There is no one space means you can create, you can type in the word form 3 format, you can put how much name you want.
Okay, so what is the maximum number of applicants that can be?
Not like it is left to you, it's left to you, okay?
Okay, sir. Can my like college name and our name can be given in the applicant name?
Yes, you can do, no problem at all.
Okay, sir. Assignee should be the college faculty, sir.
If you are assigning your rights to whom, that is left to you. You are assigning your right to college or principal or management, whom you are assigning your rights of whole invention, that is left to you, which is your decision, because you have created your new product or process or new technology. So whom to assign, it is left to you. It's your own decision, because you are creating that idea.
Sir, we have a question.
Yes.
Sir, what is the estimate, sir? How much does it cost to file patent? Because as a
Not audible. Some problem.
So, sir, how much does it cost to file a patent, sir? And
I told you, if you are filing online, 1,600 fees for the online filing. Request for example is individual 4,000, for the company is 8,000 rupees.
sir, access to college.
So 4,000 plus 1,600 means 5,600 rupees for online filing. Typically, if you are filing on individual name, 10% in addition to that. Please check the website, given fees column clearly.
So also, is there any punishments or any actions taken if somebody claims rights to our patents?
You can go to the court, that is called criminal proceedings. You can go for the court, you can infringement of patent.
Thank you.
Thanks.
Gentle reminder to fill the link, please fill the link. Okay.
I would now like to thank Dr. Bharat and Suryavamshi for his presence and for sharing his valuable knowledge to the students. I am sure it has helped a lot of us to gain knowledge on IPR and patents. I would like to extend my gratitude to the management and department for initiating this program. I also like to thank the faculty in charge, Dr. Paramasivam sir, for his support. Lastly, I like to thank the students for the presence and making the event successful. Thank you all and have a nice day.
So mute.
Now I I would like Dr. S.P. Shri, the President, S.P. Srinivasan, the President of IIC, to give a word.
Good afternoon, everyone. Thank you very much for today's speaker. And this is the first session for the semester, event semester. And thanks for all the participants. And of course, we have a lot of initiatives under this IPR and NIPM. Thanks to Institute Innovation Council of AICTE that we have initiated a lot of activities related to IPR and research and other things. So we have 25 years of academic excellence in engineering stream. Now for the past couple of years we used to file a lot of patents through this IAC initiative. Thank you very much for NIPM and IAC, and I hope all the participants got a lot of takeaways through this session, and if you have any doubts you can clarify with us even through IAC portal, and all the participants are eligible to get some kind of certificates. Please enroll your name. Please register your name in the registration link which we have already sent to you. And thank you very much for the speaker. Thank you, sir. Thank you, everyone.
Dear participants, thank you for your active participation. Thank you. Kindly fill the feedback link for the certificate. Thank you.